nice to see everybody today. I'd like to introduce our presenters. Please welcome Adrian Adams, founder and managing partner of Davis-Stirling, PLC, partner Lori Poole, and also the president of the College of Community Association Lawyers with CAI, and Nathan McGuire, partner and former chair of the California Legislative Action Committee.
And this reminder to everyone to use the chat feature at the bottom of the screen. If you have questions, just submit them there. And we will try to get to some of them, at least some of them at the end. And anything that we can't get to, we will compile and publish them through the newsletter. We're also going to be sending your questions and comments to Freddie and Fannie because they are looking at revising their questionnaire and they would like the feedback. I think it would be valuable for them. Okay, so we've been introduced. Let's go to the next one. Okay, CAI is also conducting a survey. I think they've got already 1,000 responses. You can see the link there to their survey, and they're looking to get feedback from everybody as well on the impact the lender questionnaires are having, if it's affecting them, if there are being delays on lending, if things are being denied. So it's only 19 questions. So if you have an opportunity, after we're completed here, go ahead and jump onto the link and answer their questionnaire. Let's go next. Okay, this is Champlain Towers that started this whole thing. And this is Champlain Towers as of June 23, 2021. So you can see, nice looking building. Next slide. You'll see their pool deck, well kept and clean. Next slide. A spectacular lobby, very nicely done. In fact, it may not even be original with the developer. They may have upgraded that lobby at some point. Next slide.
Yeah, having done a few renovations, I'm going to say circa maybe 2000s, 2005, 2000, maybe. That.
Very nicely done. They have a very nice gym, new equipment. Next. So obviously they paid attention to the cosmetics. Look at their roof. They're the second one from the left as compared to the other three buildings. The roof's in horrible shape. It shows a lot of deferred maintenance. Next. This is their pool room, which is underneath, and it's not easy to see, but there's a lot of efflorescence on the walls. It shows a lot of water intrusion into that area through the walls. Next. They have a lot of columns throughout that were cracking, exposing the concrete and rebar. Next. As you can see, this is what spalling looks like. What happens is when concrete gets wet, it rusts the reinforcing steel inside the concrete, and when it gets wet and rusts, it expands. And when it expands, it starts popping off the concrete. And so this is what's called spalling. And they had a fair amount of spalling going on in the building as well. Next. This is what Champlain Towers looked like on June 24. This is what's not supposed to happen. And 98 people died as a result of the collapse of the towers. It caused a huge ripple effect throughout the country. A lot of people were concerned about it. And a lot of legislatures are looking at what they can do. Reserve and analysts are looking at possibly upgrading reserve study requirements. But Fannie Mae and Freddie Mac also stepped up and decided that they were going to do something about it as well. So Nathan, tell us about Fannie and Freddie.
Yeah, let's talk about Fannie Mae and Freddie Mac.
Next slide.
So first of all, we get a lot of questions like why Fannie Mae and Freddie Mac, they sound like people. Some people have said sounds like cousins, and in a way they kind of are cousins. Both of their names are actually creative acronyms. Fannie Mae stems from the acronym FNMA, which is Federal National Mortgage Association. If you kind of squint and sound it out, FNMA kind of sounds like, comes out like Fannie Mae. A much bigger stretch, I'm not sure how you get to Freddie Mac, stems from FHLMC, which is the Federal Home Loan Mortgage Corporation. But in any case, Fannie and Freddie, or I even heard someone recently say Fan and Fred. So I guess they're just, we're becoming quite friendly with these organizations. But what are they? They're quasi-governmental entities, and they're the nation's largest players in the secondary mortgage market. What does that mean? They don't actually originate loans, even though many of us, and certainly they have the largest, I think 60+% of the secondary mortgage market.
Zach, let's go to the next slide. Okay, go ahead.
So when a bank issues a loan, if it's eligible, they can turn around and sell it to Fannie or Freddie. So in addition to creating liquidity in the market, Fannie and Freddie essentially make the market more affordable and stable because they essentially ensure the availability of loans to a large segment of the consumer population. This means, of course, that lenders work really hard to make sure that the loans that they're making are eligible. And of course, buyers and sellers are anxious to ensure that their loan is eligible because it means that there's a lot more buyers in the market for those. So that said, Fannie and Freddie both have very complicated requirements for eligibility. For example, Fannie Mae's selling guide is 1,238 pages long. It's incredibly complex. You really have to have a PhD as a lender and lots of experience to be able to get through all of that. So loans can become ineligible for a lot of different reasons, but one of the reasons that they can become ineligible is because of issues with the project that the unit is located in. And both entities have a database where they track projects that have been determined to be ineligible. And so there's a lot of these hurdles that people who are looking to refinance or sell or purchase are looking to get through because there are significant benefits if the projects are eligible for Fannie and Freddie financing. One of those big hurdles is, especially in California, is the conforming loan limits. So these range from 650,000 around all the way up to 970,800. Those are in the highest cost counties. So it's really important for both selling and refinancing units in a lot of projects, certainly some more than others, because you can reach a broader marketplace. So let's talk about CAI survey and how we'll talk about the questionnaire later, but let's jump to the next slide.
And before we jump into that, just want to remind everyone, please make sure you're muted and your camera is off. We are recording, and so we don't want to be recording the inside of your living room and posting that on our YouTube channel. Okay, go ahead.
Well,
Thanks,
and
Adrian.
I was gonna point out that, and we're leading into the CAI survey, but last month in February, CAI issued a publication. It's really helpful on determining condo and co-op eligibility for mortgages backed by Fannie Mae and Freddie Mac. And the part of the information that I found interesting in that publication is the fact that according to the Federal Housing Finance Agency, which is FHFA, I don't think they have a nickname yet. So 62% of the conforming loans are currently owned by Fannie Mae and Freddie Mac. So that gives you a good idea of how important their guidelines are and their requirements are.
Yeah, great point, Lori. I mean, you basically have a lot of people scrambling if there is eligibility issues because it could impact values in some communities. In some communities, it's not going to matter. If the if the costs are above $1 million or don't qualify because of the value of the units, then they're not going to qualify. They're going to have to get financing, what we call non-conforming financing, and so it's not going to necessarily be a huge deal. But we'll talk about the reason why we're all here. This is so important. We'll get into that a little bit later in terms of one of the concerns coming up about projects being rendered ineligible as a result of what Adrian already talked about, issues like Champlain Towers and some new guidelines. But we'll talk about that in a little bit. First, I want to talk about CAI's survey. It's very clear that the guidelines are already having an impact, and Fannie Mae's guidelines came into effect January 1st, and Freddie Mac's were, I think, March 22nd. I don't have that right in front of me, or February 22nd. But the point is, they're already having a significant impact. Nearly half of the respondents that CAI surveyed said they've experienced delays in lender approval. Of course, that results in complaints to the association. 26% have experienced loan denials due to questions not being answered. And this is not related to structural integrity concerns. What we don't really know at this point is how many denials have been made when there has been a good faith effort to answer the questions. And then some are likely being denied as a result of how the questions are answered. CAI sent a letter on February 17th to FHFA urging a delay in the implementation of the Fannie and Freddie guidelines. And so we're hopeful that that will have some effect. And because really there's just not a lot of information, and CAI lays out in their letter why it would be beneficial to delay, because as you can see, there's lots of interest, lots of projects, and people are being impacted by the new guidelines, and hence why I expect we have such a great turnout for today. So let's move on to the next slide.
Let's wait before we move on. The last point there is really important, as 88% of them felt exposure to liability for answering the questions. In fact, we're getting that's where we're getting basically panicked calls from boards, from managers. I know of at least one large management company that has instructed all of their managers not to sign any of these questionnaires. And we have boards that are volunteers that are reluctant to sign because they don't want the potential liability for signing off on this new questionnaire. And so that's why we're going to go through these questions and talk about that, because of the impact that it's having, both on the fear for being sued, being liable for answering or not answering questions, or answering them incorrectly. In fact, let's go to the next slide.
Yeah, and I mean, an important point too, CAI did issue today a press release with the preliminary survey results. So you want to check that out to see where they are today.
Okay, Form 1076, Lori, go ahead.
Yeah. So as we've talked about, that's why we're all here. You know, what in response to the Champlain Towers tragedy, the Fannie Mae and Freddie Mac have issued guidelines. They're changing their requirements for evaluating loans that are going to be in condominium and co-op projects. And so what has come out of that is this form, which it's an addendum to the existing form 476, the condominium project questionnaire. And this is form 1076, which is the addendum that has given everybody a lot of angst lately, and what we're here to talk about. It says that the condominium project, this questionnaire addendum form 1076, is voluntary, but I really am wondering how voluntary it is, again, given how important Fannie Mae and Freddie Mac are to the lending industry. And what Nathan mentioned about there is a database that they maintain. It's called the Condo Project Manager Database of condos and co-op projects that are deemed ineligible. I don't know if we're going to call it the blacklist, but it kind of acts that way. If a condo or co-op project is on that list, they're not going to be eligible for Fannie Mae and Freddie Mac forms. So again, they're saying it's voluntary, but I think we're finding that may not really be the case, and that associations are certainly being asked by their member owners who are trying to sell or refinance to fill these out. This first page of the form is pretty benign here. It does ask for the information about the lender name, the contact name, and the lender's their contact information, so that we know where the responses are going to go. But question number 1 here does ask about the project legal name. And in order to get that, the legal name of your development is, if you're incorporated, at least here in California, if you're incorporated, it's going to be in your articles of incorporation. That's where the legal name is going to be. And you want to make sure you include every apostrophe, every inc or not inc, INC, period, not period, all of the above. So.
Yeah, and I want to point out too, see the yellow highlighted portion where it says that the form has been sent to you on behalf of an individual seeking a mortgage. So it's on behalf of the buyer. And associations have no obligations to the buyers, which means that there really is no obligation to answer any of these questions. And we know that some of our colleagues in the industry, attorneys, are advising their clients, don't answer these because you're not obligated to. Your obligation is to the owner, the member of the association, the seller, and to provide information as required by statute, which most of these questions that we're going to go through are not required. But our position is that, look, Fannie Mae and Freddie Mac are trying to do the right thing here, and that is to ensure that associations are sound structurally and safe, and that's a good goal. We object to some of the questions, to the way that they're worded, and we're going to point those out as we go through. But generally, we're not hostile to Fannie Mae or Freddie Mac. We would just like to see them clean up their questions and make it not quite so burdensome on associations to answer these questions.
Yeah,
so,
and
Adrian,
I wanted to point out that the form, because we are going to go through the form, but there are 3 main areas that they're asking about. One is about deferred maintenance and unsafe conditions, because projects that have significant deferred maintenance or unsafe conditions are not going to be eligible until the repairs are completed. They're also they're going to ask questions about special assessments. And the reason for that is that comes down even more to the appraiser's job to determine what the reason for the special assessment and how the special assessment is going to impact the association's ability to fund those critical repairs, and also looking at the borrower's debt ratio. And then the third area of the questions goes to the reserve requirements. Fannie Mae is requiring that condos and housing cooperatives have to have 10% of their assessment income dedicated to reserve. So that as we go through the forms, those are really the 3 areas that they're focused on this addendum.
Yeah,
So
and Lori, I was just going to say, I think technically the reason why this is optional, 2 reasons. Number one, as Adrian mentioned, we're not obligated to fill these forms out. And they say technically the form is not necessarily a hard and fast condition for eligibility. And the reason that's the case is technically the lender could verify eligibility from independent sources. So the lender could, hire an engineer to go out and inspect the property and gather other documentation and materials. The likelihood of that happening, I think, is pretty close to 0. So as a practical matter, I think the boards need to understand that if they choose not to answer the questionnaire, then the loans will be denied.
And I think the preliminary results from CAI on their survey is supporting that.
Right. Let's go to the next slide. Okay, either one of you want to speak to this issue?
Well, so like I said, there's three main areas that the addendum is focusing on. So they dig right in and they start with asking about building inspections. When was the last building inspection by a licensed architect, licensed engineer, or other building inspector? So there's certainly some vagueness with the question. Is it an inspection of the entire building? What if a portion of the building was inspected, like the fire sprinklers or something like that? Is that what they're interested in? Also, what time period are they looking for? Fannie Mae issued a letter to their lenders on October 13th of 2021, and that lender letter actually does have a little bit more guidance. And they are recommending that the lenders review available inspections, engineering, or other certification reports that were completed within the last 5 years.
Yeah, I want to add to what you're saying. The question here says, if you'll see the highlighted portion, the building inspection. Well, probably the last time the building was inspected was when it was signed off by the building department, by the developer. So when it was first built, and it probably has not had a building inspection by any architect or building inspector since then. But there are portions of the buildings, for example, sprinkler systems, Reg 4 testing that a lot of the condominium associations have to go through every 5 years. And then you also have balcony inspections that will be coming up and due January 1, 2025. So you've got to get balcony inspections done before then. But those are not building inspections, quote unquote. Those are only a portion of the building. It's only balconies or elevated structures and sprinkler systems. So this question, I suspect they don't mean just the building. They probably mean major components in the building that are related to safety issues and structural issues in the building. But they really need to reword this question.
Yeah, and I'd like to see the time period too. If they're really only interested in those inspections from the last 5 years, I'd like to see that in the question,
right.
or maybe a set of guidelines that goes with, instructions on how to complete the questionnaire that can provide that additional information would be helpful.
Yeah, because Nathan referred to with the instructions they have to the lenders, which are how many pages? How long are these things, Nathan?
Hundreds of pages. I mean, it's very challenging. The selling guide itself is over 1,200 pages for Fannie Mae. So there's almost too much information for lenders and virtually zero information
for the ones filling this out,
for those who are tasked with filling out without the forms. I think there's just a lot of this is a theme that we're going to see throughout as we go through these questions. There's just a lot of holes. There's some vague questions. We have to sort of read other materials to really understand what they're really after. I think what they're really after is more evident in question 2, which is does the inspection have any findings related to the safety, soundness, structural integrity, or habitability of the buildings? That's really what they care about. Not, was the last time the solar panels were inspected or something like that. I also think there's a huge hole here where it says, when was the last inspection? What if we had a recent inspection that was very limited, but we had a prior inspection that was very comprehensive and actually got into and had findings related to the structural integrity of the building? That technically would arguably be missed here, because it says, did the last inspection have any findings related to the structural integrity of the building? So there's just a lot of gaps here. So that's why it's going to be very difficult to fill out these forms. I believe that we really should focus on the issues that are related to the structural soundness of the building and try to take it in the spirit in which the questions are asked, and not get too caught up in you know, in the specific questions here. Like if you've had 3 inspections in the last 6 months, I would answer as to all of them, not just the last building inspection.
Let's go to the next slide. Yeah, one of the things we're going to want to know is if you have, you know, if there has been an inspection, there are deficiencies, they want to know what you're going to be doing about it. What's the association, what's the plan, and have they documented, you know, what's in their minutes, and you have to provide that, and what the action plan is. So they want to know that the board is actually addressing those safety issues. Let's go to the next slide.
Yeah, and you can see they're asking for a copy of the inspection plus the board minutes, and the Fannie Mae letter is actually directing the lenders to review not only the reports, but the board minutes as well, because the board minutes are in theory going to provide information about, you know, what is the association doing in response to an inspection.
Okay, you'll see on number 3 on the current slide, it says, is the HOA/cooperative corporation. Well, HOAs are at least used in California, but maybe nationwide, is more generic, referring to all common interest developments. And in some areas, it's just planned developments. So it really should be, the question should be condominiums and cooperatives. And then so that's just an issue on the wording. Then going on, it says aware of any deficiencies related to safety soundness. That is such an open-ended, broad question. So that means if you've got a trip hazard on a sidewalk, are they supposed to be reporting that? I don't think that's what they want. They probably want significant deficiencies, and they want to address those. So the smaller stuff, the routine kind of day-to-day maintenance, safety issues, deficiencies, light bulbs that are out, you know, I doubt that they're interested in any of that. So again, they need to be a little more clear about what it is they want. And this is where a short guideline for the preparer filling these out explains what it is that they want would be very helpful. And they'd have a lot less resistance to the preparers for associations to prepare these things, fill them out and turn them in.
Yeah, and the CAI publication from last month in February, you know, they do talk about criteria that will make buildings ineligible for these secured mortgages, things like significant deferred maintenance and unsafe conditions, maybe deficiencies, defects, substantial damage, or deferred maintenance that is severe enough to affect the safety, soundness, structural integrity, or habitability of the improvement. So again, to both Nate and Adrian's points, that's really what they're looking for, is they're concerned obviously about the structural soundness, safety of the building.
Okay, let's go to the next slide. And Nate, can you cover this?
Sure. This is one of those, I think, the most difficult questions to answer because it's really confusing what they're getting at. I think we actually know what they're getting at, but it would be great if that was spelled out more clearly. So the question is, are there any outstanding violations of jurisdictional requirements, zoning ordinances, codes, et cetera, related to the safety, soundness, structural integrity, or habitability, et cetera? And we know from other sources, including Freddie Mac has purportedly said, this is basically about known ordinances or laws that are already in place, so not upcoming ordinances or laws. For example, the balcony inspection requirements under SB 326 in California that Adrian mentioned. But certainly by then, if it's post January 1st, 2025, and and an association has not completed a required inspection, this is really what they're after. But certainly we could read into that question a lot more potential issues there. Of course, if a project has been red tagged and is in trouble with with the local jurisdiction, things like that, then that would also likely trigger a yes answer here.
But to go what you're saying, the question, the way it reads now is like a board or management is supposed to know all of the codes, all the ordinances, know whether there's a violation or not, and they're not going to want to answer this because they don't know. Management companies don't know. The board members don't know. As lawyers, we don't know, and we don't know if there's a potential violation. So the next part there, if yes, provide the applicable jurisdictional entity. Well, it would be nice if they would say if they've received a notice of violation. But I think you're right. They're trying to read into the future and look at potential ones that the board knows about, and I just don't like the question. And then the next one is even worse. Anticipated the project will in the future have such violations. Like, get out your crystal ball and look into the future and figure out if you might have a violation. I don't like the question at all. And I think we're going to have a lot of unanswered questions when boards fill these out. They're just not going to answer it because they don't know. Okay, let's go to the next question or the next slide. Okay, this one on, does the project have a funding plan for deferred maintenance? And I think they mean reserves. Do either one of you think differently?
Yeah, it's hard to know. I mean, here in California, our associations are required to have a funding plan for the reserves and to disclose what that funding plan is to the members every year. But we don't have a statute that requires a funding plan for deferred maintenance. I also, if we were litigating this, I would object that it assumes facts that are not in evidence. It assumes there is deferred maintenance by the question, and there may or may not be. So,
although I suppose there's always some kind of deferred maintenance, because that's just routine maintenance, depending on who you ask. We don't replace the roof every day, and so it's always sort of in a constant state of degradation. And so, we know from extraneous sources and CAI's materials and Fannie and Freddie's guidelines what they're really after here, but it's very confusing in the question. Some of the materials that we've looked at make it clear that deferred maintenance does not include routine maintenance. It doesn't include improvement projects. It doesn't include repairs, which are isolated to a few units which don't impact the overall project. So if there's a fire or a flood, in one part of the building, and we're working on that, that's not going to constitute a rendered ineligibility for significant deferred maintenance components.
But if they are referring to reserves, I object to that, the whole wording of it, because reserves are, for example, you've got a roof, they have a 20-year life on it. And let's say that every year they have a roofing crew come up and do preventive maintenance on it. So there really isn't any deferred maintenance, yet they've got money set aside to replace the roof. And at the 20th year, they replace it, even though they've been not deferring any maintenance. It's just reached the end of its useful life. And so I would not deem things in the reserve study to be deferred maintenance. Yeah. And I would term it differently. But I think that is what they're after, is whether you have a reserve study, do you have a schedule for replacement of items? But then there's a second issue, and that is, what about construction defects? And you've got a construction defect settlement, and you've got money set aside in a separate account to fix the defects. Do they want to know that? And even then, that doesn't fit under deferred maintenance. It's a defect, and it's a repair of a defect, not it's something dealing with with deferred maintenance. So
yeah, these questions definitely could use a lot more guidance, or maybe certainly some fine tuning, because it could be that they are interested in, okay, if you have deferred maintenance, and Freddie Mac defines it as postponing normal maintenance, which can't be resolved by normal operations or routine maintenance, that's going to advance the physical deterioration of an element and decline in property values, increase the operating costs. if that's what they're talking about and not the reserve items, we definitely need some clarification as to what they're actually looking for.
Okay, let's go to the next slide. Okay,
we
and
talked about this.
yeah, this is just what we just covered. Okay, next slide. And that's pretty easy. You know, have they done a reserve study? And it's interestingly enough, you know, in a lot of states, they don't even do reserve studies. They're not required. But California, they are required having a visual inspection every 3 years. So associations, if any of you are on this and you haven't done a reserve study, you're not in compliance with statute, and you need to do it. You need to do one immediately.
Yeah, and these questions in California, at least under both Civil Code Section 4525 and 5300, can be answered by the information that sellers at least are obligated to provide to prospective purchasers. So in California, these should be being disclosed anyway.
Okay, next slide. Okay, the terms of special assessments. We get to the special assessments section that you were referring to earlier, Lori.
Yeah, and again, in California, under Civil Code Section 4525, you do have to disclose, or the seller has to disclose to prospective purchasers if there are any special assessments. And also, if the board has approved a special assessment that hasn't been put in place yet, that also has to be disclosed. So, you know, I don't think for California associations this is going to necessarily be that difficult to answer. But the reason why they're asking that is because the lenders expected to obtain financial documents to confirm that the association has the ability to fund repairs. So certainly, you know, what the purpose of the special assessment in 10C, that's going to be a key question to answer, because you may have a special assessment to, I don't know, furnish the pool or something, have pool furniture, which is not, you know, hopefully that's not going to make you ineligible or make your development ineligible for Fannie Mae and Freddie Mac backed funds.
Yeah, then let's jump to the next slide, because I think we address it here. You know, as you were saying, Lori, if the special assessment isn't related to the structural integrity of the building, then it shouldn't matter. But if it is, then it will render the project ineligible unless and until the related repairs have been completed, which is fair. That's really the crux of what we're trying to, of what Fannie and Freddie are trying to do here, is they don't want to invest in buildings that aren't structurally sound, and this kind of puts pressure on the board to do these basic things that should be you know, being done anyways.
Except that it does seem like they're punishing them. If the board has special assessed and they're starting the repairs, they're not going to, you know, they're making them ineligible even though they're complying and doing what needs to be done. And in the Fannie Mae lender letter of October 13, 2021, they basically say you're going to be ineligible until it's completed, as you had just pointed out. So, Lori, anything?
Well, and also 10B, the question here, what are the terms of the special assessment? And, you know, that's going to be important to, if a community does have a special assessment, especially for these safety structural issues or repairs that are being done, to set forth what the terms of the special assessment are for the owners. I assume that means for the owners to pay it back. You know, how long is the special assessment going to, you know, what was the total amount? How long do members have to pay it back, things like that, because that's all going to go to the evaluation of the financial, you know, the impact on the association's funds.
Let's go to the next slide. And this is, you know, are there any planned special assessments? And again, not clear. Is the board thinking about, you know, they're planning on, you know, putting one before the membership for approval, or is it one that's already been approved by the membership? What exactly are they after here? And again, it would be very nice if they had just a real short, simple guidelines to go with this, so that the preparer would know what it is that they're after, what do they want, and so that they don't feel, because that's why there's so much angst. They don't know what they're supposed to be filling out here, how they're supposed to answer these things, and they're afraid to answer them because if they answer them wrong, or they got to get sued. Let's go to the next.
And what if they don't answer them? But again, in California, under Civil Code Section 4525, a seller does have to disclose to a prospective purchaser whether the board has approved a special assessment, even if the special assessment hasn't been levied yet. So that is required in California to an extent.
Okay, next slide. This deals with the loan to finance improvements. I don't know why they're asking that. It seems to me, because in most cases that we deal with, the loans actually make it easier for the membership to pay, and the money is paid, borrowed up front so they can make the repairs, you get things done. So loans, in my opinion, are a good thing, not a bad thing. And I don't know how Fannie and Freddie are viewing this. So Nate, have you seen anything on this?
Yeah, no, I mean, I think this is just one more way to try to capture, is there something going on in the project? It could be a red flag if there's a big loan that has just been taken out. It could be a red flag if there's a giant special assessment on the horizon. But again, that really, at least for purposes of this addendum, is only relevant if it's related to the structural integrity of the building. There are other reasons, and including just sort of bad financial health, that a project could be rendered ineligible. I don't think any of that is relevant for purposes of this addendum, and it just confuses the issue.
Yeah, and in California, though, again, under 4525, if there is a loan, that has to be disclosed to the members on an annual basis under Civil Code Section 5300, which also then has to be disclosed to prospective purchasers. It's interesting in the documents and information that I've reviewed, before today. I see a lot about the special assessment. I see a lot about the deferred maintenance. I haven't seen anything on why they're asking this question. But I think my hunch is it goes again to that evaluating the financial health, if you will, of the association, and also perhaps the ability, the timing on making the repairs. I agree with you, Adrian. A lot of times getting a loan is going to expedite the ability to make those important repairs, because you could get the money sooner than if you're levying a large assessment and it's getting paid back over a period of time.
And it reduces the burden on the members because it spreads the payment out over time, which makes it easier for them to make the payments so that the repairs can get made.
Yeah, I mean, so that this may not be a negative thing in how they're evaluating it. I don't know, because I haven't seen much about why they want the answer to this question or why they're asking this. But in California, we have to disclose that anyway. But I'm hoping that maybe in some circumstances it could be could help an association.
Let's hope. Yeah. All right, next slide. Okay, Nathan, do you want to address this?
Yeah, I mean, this is you can see we put needs disclaimer language, and this is where some human being is going to be on the hook here to put their name down and their title and their email address and sign. Ultimately, their name is associated with this, and it's that is a daunting thing. And so, of course, as we'll talk about in a minute, we're recommending caveats and disclaimer language all over the place from every possible angle here. But it really would be great if the form itself recognized that this is not intended to create liability for the person who's actually attaching their name to this addendum. It could be something very simple to basically say that the responses are based on the preparer's information and knowledge as of the date that the questionnaire was completed, and that they don't guarantee the accuracy of the responses, and something just very simple, because as we mentioned earlier, I mean, 88% of people who are responding to CAI's survey are concerned about the liability here. And of course, we have thoughts about that, but the reality is someone is going to have to associate their name with this addendum. It's going to have to be a board member. It's going to have to be a manager. Ideally the manager, although as Adrian mentioned, some management companies are refusing to do this. So if nobody's willing to do it, people should be made to feel comfortable to provide the best information that they have. And that should be the end of it. They shouldn't have to be concerned that if there was some latent defect that they weren't aware of, that it's going to potentially come back on them.
Yep, and being California, everybody is either a lawyer, married to a lawyer, has a family member a lawyer, knows a lawyer, and so people are afraid to sign these things because there's no disclaimer language, and so they think that they're on the hook. And as you pointed out, almost 9 out of 10 people who responded to CAI, they're concerned about the potential liability. Let's go to the next slide. Okay, so on our recommendations and talking about the liability issues, the first one, if you don't answer the questions, loan will be rejected and the sale falls through. Well, Fannie Mae has already said in their the material that they put out that it will. That they're not going to, they will be ineligible if they don't answer the questions. And of course, if the loan falls through, you've got the seller who may threaten to sue the association and the buyer who may want it, threatening to sue the association. And so that's one of the downsides of not answering the questions. You may avoid that fear of potential liability by not answering anything and not signing anything. But then you've got, on the other hand, the potential that you're gonna get sued because you didn't answer it. Although, as we pointed out, in some of these questions, you're not obligated to answer them. And as Lori's been pointing out, the ones that you are obligated. Okay, and so then if you do answer the questions, buyer relies on it as an incorrect answer, and as Nathan pointed out, then are you going to get sued? So again, the fear to answer these questions. And if it's incorrect, is that something that that Fannie and Freddie are going to do something, or a lender will? We don't know. But I think we need, as Nathan pointed out, to eliminate that problem with some disclaimer language in the form itself, so people aren't afraid to answer the questions and afraid to put their name on it.
Yeah, whether it's in the form or in some type of document that is, given, that would have appropriate disclaimers, which would explain the context in which the answers to the questions are being submitted.
And of course, I'm surprised this is the first time we're going to say this on this webinar. Consult with your own legal counsel. Right. But I'm going to go out on a limb here and say that in most situations, I think while this is California, anybody can sue anybody, and certainly it's an annoyance to get sued. We don't want to get sued. But in either of these cases, either you don't answer the questions or you answer them to the best of your ability and in good faith, then I think that there are significant protections, and that the risk of actual liability to the preparer and or the association should be very minimal, should be nominal.
Let's go, and I agree. Let's go to the next slide on our recommendations. And should you answer, Nathan said, consult legal counsel. We're not giving legal advice here, but we're giving our impressions on how this form, how we think it applies and what should be done. And so we recommend, as Nathan pointed out, cautious responses. And we are in the next column there, you see who should answer, management or board, along with a disclaimer. And so we prepared a disclaimer letter to accompany the questionnaire to provide some comfort to those who are preparing and putting their name on these on the forms. So comments from either one of you?
Yeah, I mean, definitely, I think a disclaimer letter needs to go, and that, like you said, we're we prepare that. That's what we're going to be providing our clients that ask us for a disclaimer letter that's going to explain the context in which the questions are being answered, that they're being answered as of a certain time period, to the best of the responders' knowledge, things like that. That's what we want to make sure that they understand while we're answering the questions. They need to understand the context of what we're answering, and more importantly, what we're not answering. And then also, certainly associations are going to need, and managers are going to need to work with their boards and legal counsel to help in actually providing the specific answers, especially if there have been inspections that have been done in the last 5 years on any issue that could relate to structural soundness, safety, all of the things that they're concerned with.
Yeah, and I suspect a fair number of the questions may be answered with "we're not aware of any problems" or aware of any deficiencies, which is, I would think, perfectly acceptable. If they're not aware, if they don't know, they don't know.
Right.
Okay, let's go to the last slide. We're going to be going into questions, Q&A here. And just a reminder, we're going to be posting this on our YouTube channel, and you can see there on the slide where you can find our YouTube channel. It's HOA Legal Issues, and this is where we keep all of our 2-minute videos that we've been producing. We're also going to be, as a reminder, seeking CLE credit for managers. We'll let you know when we get that approval. And we're not going to be able to answer all questions right now, but we will answer some. And the unanswered questions we're going to be compiling and answering them probably through the newsletter and letting so people can follow and see what has been asked. And then we'll also be sending your questions and comments to Fannie and Freddie to assist them in revising their questionnaire. So let's go, Melina. Do we have any questions for us?
Yes, thank you, speakers. We're going to move on to the Q&A. We're going to go ahead and have a rep who's going to go through the questions and ask them audibly so that the speakers can respond. Again, we ask everybody to remain muted, and we'll address the questions now, and any we can't, we'll address after the webinar.
Thank you, Melina. Hello, speakers. Who is actually getting the questionnaires? Boards, buyers, sellers? How can we get a copy of this addendum?
So
Okay.
we're seeing it through the management companies. A lot of management companies have certainly been alerted to this, and we're seeing that the management companies are informing all of their condo boards about this situation and providing them with direction. Usually the direction is to consult with their legal counsel. So that's what we're seeing. One of the things we're recommending to our clients too is to have the associations, the condo associations, co-op associations, notify their members of this situation so that if a member is selling or refinancing, they can be prepared. They understand what's happening.
Yeah, and it's usually the realtors, because once it goes into escrow between buyer and seller, then all this stuff starts coming out of escrow, and the realtors are telling them who to contact. And as Lori pointed out, it's going to be the management company, and the management companies then alert the board.
Yeah, and the addendum, we can check. I know CAI has some good resources. The Adrian or Nate, do you know if the addendum form is actually posted on CAI's websites? We can post it too. We can provide it.
We'll post it.
I believe it is, but we'll post it. It's also available if you Google search Fannie Mae Form 1076.
Yeah, and as we pointed out too, this is a temporary addendum. Fannie and Freddie are working on cleaning up these questions. Hopefully that they're listening and will really listen to the spirit of what we're saying here, because we generally support what they're doing. It would be associations need to make sure that they're taking care of safety issues and their structure. And I think that California, we're ahead of the rest of the nation in that we're requiring balcony or exterior elevated elements to be inspected for structural integrity. And I think that's going to be a real plus for associations in California.
Yeah, and even though the guidelines are temporary and the addendum is temporary, I mean, it's not going away. It's going to become it's not like it's temporary now. We're not doing it anymore. That's not going to happen. It's going to become permanent shortly.
Yeah, I think best case scenario is likely that there's a temporary delay in the requirement as CAI has asked for, but also that the form itself is cleaned up and simplified and made a lot more clear and straightforward.
Okay, next question.
Relating to the first question on the form, is there a statutory requirement for regular inspections of the buildings aside from balcony reserves? And would a condo project already have some reason to have regular building or structural inspections?
Okay, there's nothing that I'm aware of requiring it, aside from the 3-year inspection by the reserve analyst, but they're not acting as a licensed engineer doing the inspection, and they're not looking at structural integrity. So it's the balcony inspection, which is going to be every 9 years, that is actually looking at structural issues. There are, for condominiums that are sprinklered, especially the high rises, the Reg 4 testing, which is, I believe, every 5 years, looking at the safety systems in the building. Other than that, I can't think of anything. Can either one of you?
There may be some local requirements that come into play, especially going forward. I know various counties and in the state, they're looking for, they're looking to impose requirements. Some of those requirements might be, on local jurisdictions as opposed to on, the communities themselves.
Yeah, I think, wasn't that even the situation with Champlain Towers? Wasn't it there was a local inspection, 40-year inspection that was required?
Right.
And I agree. I think the answer to the question is, other than the ones we've mentioned, I would actually say not yet, because I would really, I'm suspecting we're going to see legislation proposed.
That's not to say that local jurisdictions don't come in and inspect if there are reasons to do so, if they notice something or if people are complaining, if there's elevated structures or structural integrity issues and they're being reported to the local jurisdiction, even before now, but certainly going forward, I think we'll start to see that ramp up. But certainly, we've had associations where portions of the project are red tagged because of structural integrity issues.
Okay, Rachel, next one.
Really quickly, when do we want to stop with the questions, just so I can?
Let's do a few more questions and then we can stop.
Okay, we have recorded all questions and I know you guys will be answering them. Next question, would a reserve study inspection be considered a building inspection? What about inspections by construction defect experts?
Okay, well, I don't think that the reserved inspection is considered, what you're looking at structural issues. They're looking at from just an exterior visual of major components. So they're not looking in the walls. They're not doing what I think that Fannie and Freddie are after here. So I don't believe that that's what's would qualify. Do either one of you think so?
Yeah, well, I mean, the question is, when was it inspected by a licensed architect, licensed engineer, or any other building inspector? So, I mean, licensed architect, licensed engineers, very straightforward, but other building inspector is certainly up into interpretation. But I agree with you. I don't know that a reserve.
Although some reserve analysts are engineers, and so, but they're not doing it as an engineer. They're just doing it for the reserve study.
No, I mean, I think this is where we've written into our kind of draft responses that you're going to end up providing a lot of information about the reserves, but we're not necessarily going to characterize it one way or another as a building inspection. But we'll say, here's what we do, and here's the information about our most recent reserve study, and et cetera, and go from there.
Yeah.
Okay, next question.
If you have not had a building inspection, doesn't this pretty much stop the questions from being answered?
Well, I think you still have to answer the question, but the answer is no.
Yeah, and there are other questions that are relevant. So you just can't stop there and not go to the rest of the questionnaire.
Right, because like I pointed out, there are several questions in the questionnaire that you're already in California required to provide that information, or the seller is. Yeah,
and then there's the whole issue of when how are you defining building inspection? So, is the balconies inspection qualify? I think that's what they're after, but that's not what it says. Okay, next question.
What if a board refuses to do a reserve study? Do all reserve studies require a visual inspection?
Yeah, well, every 3 years are required by statute to do a visual inspection, and all associations, I believe, are required. There may be an exception. There was a small exception for what smaller associations. There was a dollar amount, but by and large, most all associations in California are required to do a reserve study.
Can engineer inspections be paid from a reserve account?
Oh, good question. Yes.
Sure.
So,
Because the reserve account is funds for those components with a useful life of 30 years or less, for the eventual repair and replacement of those components. So certainly obtaining an inspection of those components is part and parcel of.
right, it qualifies.
Mhm.
We are getting questionnaires from owners refinancing, not selling. Does this change the requirement?
No.
Same.
Our HOA has a board of volunteer owners and is managed by an HOA management company. In this case, who would be responsible for signing the questionnaire?
Well, the management company is the agent of the association who acts through its board of directors. And so if they refuse, as some of them have already notified us that they're refusing to sign, the board is obligated if they're going to fill it out and turn it in. So and some management companies are willing. I think Nathan or Lori, you're aware of some management companies that are, but under certain circumstances.
Yeah, I mean, I think the management companies are falling into kind of two camps. One is we're not gonna fill it out at all. We're not gonna do it at all. Or others we'll do it, but we're only going to do it as you direct us to do it after you've consulted with legal counsel.
Well, and I think that's the way that it should be. I think that one mistake here that we want to avoid is the board having a meeting and the outcome of the meeting is direction to the manager, go fill it out, but with no specificity as to how. I think the details should ultimately be signed off and approved by the board. That's why one of the things that we're offering to clients as part of our service in this regard is basically a written board resolution, which the board works on with the manager and fills it out, which describes exactly how to answer each question. And of course, the manager is going to have a huge part to play in terms of developing that resolution, but ultimately the resolution is adopted by the board. And that's where the authority should come from. And hopefully that will make more managers feel comfortable doing the form.
Okay, Rachel, one last question. This will be our last one.
Okay. Would a letter of intent be considered deferred maintenance during this process?
Oh, I don't understand the question.
Yeah.
Let's skip that and go to another one.
Okay. Multiple buildings in a condo, one has water damage. Owner is displaced. When the question's asked about habitability, does that have to be addressed for other units in other buildings?
Nathan, I think you know the answer to that one.
Yeah, no, I mean, the materials that we've seen suggest that an issue which impacts a few units, I don't know exactly what that number is, but will not render the project ineligible. That said, I think you're in a position where you should provide the information and let let them determine whether it qualifies or not. But it should be the case that a leak or a fire, that is the result of some specific, catastrophic event happening that only affects a few units, but not the habitability of the building overall. would not render the project ineligible. If it does, we haven't said this, so I do want to say this before we close. If a project is rendered ineligible, that doesn't mean that it stays on the blacklist forever. It just means that it's there until the project the issues that rendered the determination of ineligibility can be specifically addressed. So if that's issues with with a structural issue or an inspection, maybe another inspection is done, maybe some repairs are done, whatever it is, those issues can be addressed, and then the project can become eligible again.
Yeah, and the Fannie Mae letter talks about damage or deferred maintenance is isolated to one or a few units and doesn't affect the overall safety, soundness, structural integrity, or habitability of the improvements. Then the eligibility requirements do not apply. So one or a few units.
Probably a fair number of a fair percentage of condominium projects and co-ops have some sort of leak issue at at some point in time, and so a leak that stems from a dishwasher backing up or something and affects a couple of units should not render the project ineligible.
I agree. Okay, well, this will conclude it. One of the things that we're going to be doing is talking to Fannie Mae and Freddie Mac. And once they revise their questionnaire, invite them to participate in a future webinar that we have here in California with everyone, and just go through the questionnaire and the revisions that they've made. So hopefully this will be very helpful to them in revising their questionnaire. And what I'd really like to see is a little, short guideline to go with it, so that the preparers will know exactly what it is that is wanted of them. So anything else you guys want to say before we sign off?
I would just say reach out to us if you need help. We're here, and we're happy to work with our existing clients, or if you're looking for a law firm to assist with these or other issues, please reach out. We have developed an entire comprehensive package of information designed to help our clients navigate these very complicated issues, and it will serve to protect, not only to help guide the association and the board, but it will serve to protect the association and the board, because they will be essentially following the advice of professionals. And frankly, this is one case where I think you're going to need it. So
Yeah.
especially if you don't have existing legal counsel, please reach out.
And thanks for joining us today. We had a large number of attendees. We are really thrilled with the turnout. So thank you so much.
Thank you, everyone.